Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, once in a while, I'm sitting around in the evening, reading an opinion, reading a brief or something like that, and you find a section of it and you're like, wow, that's really good stuff. You know what? I can do a whole video on it. And this is one of those moments. Now, it has to do with a case. We're going to talk about it in a moment. It's a challenge to California Senate Bill 2 and all of the new restrictions where no matter what your concealed carry status is, you can no longer carry a firearm in basically the entire state of California. And there's an ongoing challenge to that. And as we know, there is an injunction in place on some of it. So we're going to talk about that case. But what I'm really going to do is we're going to dive into something really deep in the memorandum and support by the plaintiffs here, because I found it to be really, really fascinating, very well articulated. I think it's going to help educate all of us. So today, let's spend a few minutes and let's answer this question. How lawful are those who conceal carry? Okay, so the theory we're talking about today, and we argue this all the time, every time we're having a debate with those on our more liberal side of friends here, which is that, hey, you know, those who have concealed carry licenses are in fact the most law-abiding community anywhere in the United States. Is that true? We're going to actually take a look at some data today that was not researched by me, but by someone a lot smarter than me, but it's going to actually probably support that argument, okay? Now, the case we're talking about today is a case called May v. Bonta. The case is out of California. It's a challenge to Senate Bill 2 and all of the new restricted areas where nobody can carry a gun anywhere in the state of California, regardless of your concealed carry status. Now, there are two very well-known plaintiffs. One is a gentleman named Reno May. Many of you probably already follow his channel on out here in the YouTuberverse. It's an excellent channel. I've been following it for quite some time. Check it out. We're going to link it up down below. The other guy is a gentleman named Anthony Miranda, okay? And many of you know him as Armed Scholar, okay? And we'll link his page up below. He's been doing fantastic work. He geeks out on things like I do. So two really well-known plaintiffs. Now, all of the research on this, I'm not taking any credit for this, I just geeked out on it, found it, and I'm going to regurgitate it for you, is done by Costas Moro. And we're going to link up his Twitter handle or X handle or whatever the hell we're calling it now right down there. He is doing amazing work. You really do need to follow him on Twitter, X, whatever the heck we're calling it right now. Absolutely fantastic work. And I also believe that he is the author of this portion of the memorandum. Now, you're going to find this section, and we'll link up the pleadings for May v. Bonta down below. You're going to find this on pages 30 to 35 of the memorandum, okay? And this is the discussion about how lawful are those that actually do have concealed carry licenses. Now, obviously, the state of California keeps saying, but we need this to save lives, and that whole interest balancing test was checked out more than a year ago now with Bruin. However, when determining whether or not there should be an injunction in place, there is some balancing that the court needs to do, which is what are the harms and the interests that play between the two parties here, okay? But one of the things that plaintiffs' counsel very correctly points out is, unlike plaintiffs who would have their rights to carry eviscerated because they could carry almost nowhere, California will face no hardship whatsoever. Indeed, neither the legislature nor the governor cited any evidence that people with CCW permits, those subject to Senate Bill 2, are causing a significant amount of gun-related crime. They did not because they could not. No such evidence exists. And then Mr. Morris goes through and some historical data first in the state of California, which is in a previous run on this, which was a Senate Bill 918. Now, Senate Bill 918, had it become legislation, would have essentially been what Senate Bill 2 is. It would have made large swaths, almost the entire state of California, a gun-free zone. All of the California Sheriff's Departments and Association had actually opposed that bill and were quoted as saying, individuals who go through the process to carry concealed legally are exceedingly unlikely to violate the law. Yet Senate Bill 918 turns much of them into non-carry zones that will do nothing to foster public safety. But then Mr. Morris does an excellent job of tearing through many other states, because apparently California doesn't like to keep data on this. They just like to make these bold and brash claims. But other states actually do keep data on this. Take, for example, what he found in the state of Texas in the year 2020. See, in the year 2020, there was 1,626,242 concealed carry holders. There was a total of 26,304 violent crimes committed, 114 of them were committed by concealed carry holders in the state of Texas. So while the amount of concealed carry holders in the state of Texas amounted to 5.7% of the population, the amount of those who committed violent crime, comparably speaking, was 0.0433%. And then actually he dug a little further and discovered, if you take a look at the crimes that were actually involving the use of a firearm in an aggravated assault, the state of Texas had 1,441 of them. However, only 4 of those were committed by a licensed concealed carry holder, or essentially 0.277%. Consider what he found in the state of Florida. Since 1987, the state of Florida has issued 5.8 million concealed carry licenses. And as of 2023, 2.5 million were currently active. During that 26-year time period, roughly 18,000 of those concealed carry licenses were revoked, or 0.3%. And that goes for people who had it revoked for multiple reasons. So even if we assume that in arguendo, all of them were revoked because the person had engaged in some sort of nefarious activity, it still only amounts for 0.3%. Consider the state of Wisconsin. Between the years 2021 and 2022, Wisconsin had 458,630 concealed carry licenses. Only 1,334 of them were revoked. However, when you pare it down to how many of them were revoked for criminal activity, it was actually only 539, or 0.12%. Illinois, a state that has no problem with crime. What did the data show there? According to an article in 2020 in the Chicago Tribune, there were 315,000 concealed carry holders in the state of Illinois. Between 2014 and 2020, there were 71 incidents of firearms being used. But, and this is important, that was firearms being used, not every time that a firearm was used and then the person was charged with a crime. So there may have been many incidents which a firearm was used rather lawfully and no charges were filed. But again, assuming in arguendo that all of them actually constituted criminal conduct, but assuming all 71 incidents were, that would still only amount to 0.02% of all aggravated assaults during that same time frame. What did they find in the state of Minnesota? Well, in the year 2021, the state had 387,013 concealed carry licenses. That same year, there were 80 firearm crimes which were committed by a licensed carry holder in the state of Minnesota, or roughly 0.02% of the time. And as plaintiff counsel also points out, there are probably other states with similar data, but these 5 examples, along with the California State Sheriff's Association letter opposing the failed Senate Bill 918 and the opposition to Senate Bill 2 by numerous police organizations this year, make the point. Even if California could use public safety as a reason to curtail the right to carry in places that are not truly sensitive, and it cannot because Bruin forbids such interest balancing, people with carry permits are dramatically more law-abiding than the population as a whole, and are thus very unlikely to pose a criminal threat. Listen, the case once again is May v. Bonta. We'll link it all up down below so that you guys can geek out on the pleadings yourself. Kudos to Costas Morrow and to all the plaintiffs' counsel. Kudos to our 2 well-known plaintiffs. We'll link up Reno May and Armed Scholar down below so you guys can geek out on their channels. Please check them out. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information's right down there in the description box also. In the meantime, let's all remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. And stay safe.